My phone does not ring after midnight. I made certain of that years ago. One number goes through unconditionally. 1, Patrice. So when the screen lit my bedroom ceiling at 200 in the morning, and her name appeared, I was already upright before the second ring. What came through wasn't a voice. It was the sound a person makes when they've been holding something terrible for so long that when it finally breaks, it doesn't come out as words. Wet, fractured breathing. The sound of someone reassembling themselves enough to speak. Dad, I was on my feet. Where are you? District 4. The police station. A swallowed sound. His lawyer is already here. He got there before the paramedics did. They're saying I fell. They're saying I have a history of episodes. Don't say another word to anyone, I told her. Not to the officers, not to the lawyer. You tell them you're waiting for counsel. Can you do that? A pause? Yes. Good. 31 minutes. I'm Walt Greer, 61 years old. For 29 years, I ran Greer Electric and Service out of a shop on Morse Road in Columbus, Ohio. Residential, commercial, industrial retrofit, whatever the work required. At our peak, we had 19 guys on the payroll and 3 trucks running 6 days a week. I built that from a second-hand panel truck and a contractor's license. On one operating principle, my first foreman taught me on my second job, in electrical work. Imprecise thinking gets people killed. Before you touch anything live, you stop. You assess the full system. You don't let someone else's timeline push you into a decision you haven't finished making. I sold the business 4 years ago. My terms, my timing. I moved out to my property east of Columbus, 8.3 acres, assessed at $312,500, my name alone on the deed, and did what I had earned the right to do. There's a shop out back where I still keep my tools. Land that belongs to me in the way things belong to a man who built everything he has from the ground up. I tell you this because Clive Aldwood had spent 5 years reading me as a retired tradesman with a rural property and no active leverage. He had built a 21-month plan around that reading. He had been wrong about nearly everything that mattered. Patrice was 24 when she married Clive. He came with a firm handshake and a job title, commercial property manager, and a composed confidence that adjusted depending on the room, warmer toward me, flatter with her friends, a different register entirely with strangers he wanted something from. I said nothing. Patrice was an adult and her mother had passed 6 years earlier. The last thing she needed was her father treating every family dinner like a job site inspection. So I watched visits getting shorter, Patrice apologizing in the careful way people do when they've learned to get ahead of someone else's reaction. A Christmas 5 years ago when Clive corrected her at the table, not loudly, precisely, and she went quiet in a way that required me to look at something else. I brought it up once. She told me it was her life, and she needed me to trust her. I stood down. What I did not do was stop paying attention. About 5 weeks before everything came apart, Clive was at my property for dinner. He borrowed Patrice's tablet to show me a property listing. What I noticed was how he used it, both thumbs, no hesitation, navigating her apps without asking where they were. When he needed an email, he went to her mail application first before correcting to his own. That was not borrowed familiarity. That was practiced familiarity. I filed it where I file things that don't fit, but don't yet have a category. I knew District 4. In 2009, Greer Electric pulled the panel upgrade contract for the station's east wing, old building, knob and tube in the walls, since before I was born. We spent 11 days in there. I knew the overnight supervisor's desk sat left of the main entrance. I knew the fluorescent fixture above the second hallway had been running on an undersized ballast since we flagged it in our punch list. Nobody with budget authority had ever fixed it. I pulled into the parking lot at 2:38 in the morning. The fixture was still running warm. Chief Pete Mullen met me at the side corridor entrance, not because anyone had called him specifically, but because when the desk sergeant said my name, word moved through that building the way it had moved through buildings for 29 years. Pete and I had known each other for 17 years. Not socially. Professionally, the way men in trades and civic work build a mutual accounting of who shows up and who doesn't. 3 of his station's electrical projects had been on Greer Electric's list. I had shown up on time, done clean work, and never padded an invoice. Walt, Pete. That was enough between us. He walked me to Patrice himself. She was in a side room off the main corridor, a witness room, not a holding cell. Pete had already made at least one decision before I arrived. When I came through the door, she looked up. The left side of her face had swollen badly. The bruising had deepened and spread from her jaw toward her ear, and her left eye was nearly closed. She held a melting ice pack in both hands. The way you hold something you've been told not to put down. I sat beside her, not across from her. I took the ice pack and repositioned it correctly against the highest point of the swelling. She exhaled slowly. "His lawyer is already here," she said. Same words as the phone, different weight now that I could see her face. "I know," I said. "Tell me everything." From the beginning, she told me. It had started with a set of bank statements Clive left in the tray of their shared printer. Not her account, an account she didn't know existed. Large deposits on irregular dates, 4 of them corresponding to dates when he had told her he was traveling for work. When she asked him about it, he smiled. That was what frightened her most, she said. Not anger, the smile. He told her she was misreading the documents, that she'd been under stress, that perhaps she should speak to someone. He took the folder from her hands without raising his voice, and by that evening it was gone and the drawers of his home office were locked. She didn't confront him again. She opened the notes application on her phone, created a locked file and started writing. Dates, statements, things that didn't add up. She had been doing that for 21 months. 3 nights before everything came apart, Clive came home after midnight. She was awake. He asked why she was still up. She said she couldn't sleep. He looked at her and said, "You've been going through my things." Not a question. She denied it. He reached out and grabbed her jaw. He said, "You need to learn what belongs to you and what doesn't." Then he slammed the left side of her face into the doorframe. She fell. When she stopped moving, he picked up his phone and called Earl Sondheim. Sondheim arrived in 40 minutes. The paramedics arrived in 55. By the time the officers had taken statements, the framework was already assembled. Patrice had a history of emotional instability. She had become agitated. She had fallen. Sondheim was calm, measured, and had arrived with documentation. They were almost believing it, she said. They were building toward believing it, I told her. There's a difference. I stood. Don't speak to anyone until I come back. If anyone enters this room, you say 3 words. I have counsel. Earl Sondheim was in the corridor. 60-something, composed expression, the practiced stillness of a man who had learned to make opposition look irrational by contrast. He saw me coming and recalibrated in about 2 seconds. Mr. Greer, he'd done his research fast. I wasn't aware you were involved. My daughter has counsel as of this moment, I told him. Anything his client's account claims about her mental history or the events of tonight gets addressed through her attorney, not through this building. He asked who her attorney was. Nora Bassett, I said. Something behind his composure shifted. He recovered it in under a second. But I have watched people recalibrate for 29 years, and I know exactly what a man looks like when a name just cost him options. I called Nora Bassett from the parking lot at 3:14 in the morning. She answered on the second ring. Nora, it's Walt. I need you awake. She was ready by the time I finished the second sentence. By morning, Nora was on the phone with Patrice, walking her through the statement process line by line. Pete had opened a formal investigation and placed Clive in a separate holding area, with a 48-hour hold pending review. And Sondheim had made 4 calls in the corridor that I had observed from a distance, the last of which had left him, for the first time that night, visibly recalculating. Patrice stayed at my property for 5 days. She slept through most of the first day, the deep collapsed kind of sleep that comes after a body has held itself in sustained emergency for too long. I checked on her twice, left water and food, and left her alone. I had work to do. Nora had already pulled the incident report and was reading it for structural errors. She confirmed what I had read in Sondheim's posture. The language around Patrice's mental state had been constructed with precision. The word unstable placed just carefully enough, not inflammatory, but specific enough to reframe everything that followed as symptom rather than evidence. On the second day, a woman named Cindy Marsh called from Heartland Federal Bank. She was their security manager. She told me that 8 days before the incident, the bank had received a request to register a general power of attorney on my primary account. The individual submitting the request had identified herself as Patrice Aldwood and presented documentation claiming I had authorized the arrangement. Their legal review team had flagged the notarization before processing. The certifying notary's registration number corresponded to a suspended license in Ohio. The request had been denied. The account had been flagged for monitoring. She was calling to notify me directly per their protocol. I asked when the request had been submitted. 4:47 in the afternoon, she said. Patrice had been sitting at my kitchen table at 4:47 that afternoon. She had not made that call. Someone had used her name, prepared documentation in her name, and submitted it against my account. I called Nora. Her response was one word: perfect. On the fourth evening, I picked up Patrice's tablet from the coffee table to move it to the charging dock. The screen activated. Clive had used the device 5 weeks earlier at my property. The same evening, I had watched him navigate it without hesitation. He had not logged out. His personal email was open on the screen. I set the tablet back down, did not touch anything further, and called Nora. She called Roy Hartwick. Roy was a former federal agent who had worked with Nora on 2 previous cases. He was at my property within the hour, documented the device's state and contents, and walked me through what he found at my dining table afterward. There was a folder in Clive's email containing 17 months of correspondence, a thread with Earl Sondheim going back 14 months, a thread with a Dr. Alan Pruitt, psychiatrist, private practice, with 3 attached payment records, $7,400 each, all cash, each one preceding a document titled Competency Assessment Framework, working draft, prepared for a woman who had never sat in his office. A thread with a man named Gil Teague, whom Patrice had described to me as a dinner guest 18 months earlier, whose messages to Clive were short, financial, and unambiguous. In a single email sent 8 days before Patrice called me, Clive, to Sondheim, she found the statements. We need to move the timeline up. Is the POA documentation ready? Sondheim's reply. 4 minutes later, ready when you are. But if she contacts her father before we file, we have a problem. Clive's response. She won't. I read that exchange twice. Then I closed the laptop and sat alone at my dining table for a few minutes. He had been running this for 21 months. He had paid a psychiatrist $22,200 to construct a medical case for a woman who had never been his patient. He had used Patrice's name to attempt access to my financial accounts with a forged notarization. He had retained one of the most capable domestic litigation attorneys in the state well before he ever needed one, and he had missed a repayment deadline to Gil Teague. Roy's reconstruction of Clive's financial position put his total debt burden at $634,000 8 weeks before the incident. When Patrice found the bank statements that same week, her awareness had stopped being an inconvenience. It had become an emergency. The violence was not the beginning of his plan. It was the end of his patience with it. Nora filed for an emergency protective order that evening, citing the documented physical injury, the Heartland Federal Bank attempt, and the email evidence establishing a financial conspiracy predating the assault. Pete called me the next morning. The DA's office had taken interest in the Pruitt payments and opened a parallel inquiry. Within 3 days, federal prosecutor Harold Fenn had reviewed the complete filing and requested a meeting. I told Patrice everything that night, all of it without softening. She was quiet for a long time. Then she asked about the bank, I told her. She said she had never authorized anything and would never have. I told her I knew. She put her hands over her face and sat that way for a moment. Then she lowered them. What do we do now? We stop letting him set the terms, I said. The federal courthouse on Grant Avenue was built in 1931, 14 steps from the sidewalk to the entrance. Gray stone, 4 columns, the institutional permanence of a building designed to outlast whatever happened inside it. I had been inside it twice before on consulting work. I had never walked in as the injured party. It felt different. Not unfamiliar, different, more personal. The way a tool feels different when you're using it for your own repair rather than someone else's. Nora was beside me. Roy Hartwick 2 paces behind. Patrice to my left, moving carefully but moving straight. The bruising had faded to yellow at the edges. She had covered what remained. What I noticed was how she walked, chin level, pace steady, the particular posture of someone who had made a decision about how they were going to enter a room. I had not taught her that directly, but somewhere between childhood and that morning, she had learned it. We went inside. The preliminary hearing was before Judge Carol Spate. 23 years on the bench. A method of asking clarifying questions that consistently revealed exactly what she intended them to reveal, not aggressively, but with the patience of someone who understood that patience itself functions as pressure. Sondheim knew her. He did not look comfortable. Clive sat at the defense table in a suit I recognized. He had worn it to my property 3 years ago for a dinner where he had shaken my hand and told me how much he valued the time we spent together. He sat with practiced composure, the composure of a man who had rehearsed it extensively and was now deploying it the way you deploy a tool you've prepared in advance. He did not look at me when I entered. That told me enough. Harold Fenn presented the case in sequence without performance. He understood that what persuades is architecture, not volume, that when the structure is sound, the clearest presentation is the strongest one. First, the medical documentation. The ER physician's assessment of Patrice's injuries, 4 sentences that established the pattern of impact, the anatomical evidence, and the incompatibility of that evidence with an accidental fall. It took approximately 90 seconds to read. It took less time than that to dismantle Sondheim's account. Second, the Heartland Federal Bank records. The timestamp of the POA submission, 4:47 p.m., entered alongside Patrice's documented presence at my property that same afternoon. The denied notarization, the suspended license, the bank's written record of the denial. Fenn presented these without commentary. He didn't need to comment. The documents placed 2 things in the same moment that could not both be true. Third, the Pruitt payments. 3 transactions, 7,400 bonaries each, all cash, each one preceding a document prepared for a woman the psychiatrist had never examined. Fenn let that sit for a moment before he moved on. He understood the value of silence after a specific kind of fact. Fourth, the email evidence. Roy's documentation indexed chain of custody established by his record as a former federal agent, presented to Judge Spate with the practiced ease of someone who had prepared it, knowing exactly where it would need to hold. She reviewed the index. Then she looked up at Sondheim counsel. Your position on the email evidence? Sondheim rose. He challenged the chain of custody. He was precise and smooth and gave her exactly what he had prepared. Fenn addressed the chain of custody documentation directly. Nora noted quietly, from beside me, that the court's evidentiary committee had already reviewed the preliminary assessment page reference provided. Judge Spate looked at the document, then at Sondheim, then she moved on. Sondheim sat down, his expression held. But something around his eyes had adjusted by a fraction that only a person trained to look for it would catch. I caught it. The moment I had been waiting for came during Fenn's presentation of the Gill-Teague connection. Roy had reconstructed Clive's financial position through public filings and legal discovery. The picture was not simple. A series of informal debt instruments. A property in an adjacent county partially pledged, without Patrice's knowledge. And a repayment deadline to Teague for a sum and arrangement Roy had documented in the clearest language the evidence supported that had passed 8 weeks before the night Patrice called me. The timeline answered the question that a proceeding like this always generates eventually. Why then? Why that night? Why the acceleration from a calculated patient 21-month operation to an act of direct violence in a single week? The deadline had passed. The bank's POA attempt, Clive's last available instrument, had failed. Patrice had found the statements and refused to cooperate further. Every mechanism he had constructed over 21 months had collapsed in the span of days. And when the plan was gone and the pressure remained, he had reached for the one thing he believed he could still control. He had been wrong about that too. Sondheim requested a recess after Fenn completed the Teague section. Judge Spate granted 15 minutes. I walked to the corridor with Nora. Roy followed 2 paces behind in the quiet, watchful way I had come to understand was not deference but ongoing assessment. He's going to offer, Nora said. I know. Cooperation on Teague, Clive's testimony, and records, in exchange for mitigation on the domestic charges. Fenn may want it. Teague is the larger case. Fenn will make the decision that serves his prosecution, I said. Our position is that the domestic charges are documented completely enough that mitigation doesn't mean disappeared. The physical evidence in Patrice's statement don't become negotiable because Clive has something useful to offer on a separate track. She nodded. Then, and Patrice? I looked down the corridor. She was standing near a window at the far end, alone, watching the street below. Her back was straight. Her hands were still. She's going to be fine, I said. When the hearing reconvened, Sondheim made the offer. He framed it with the smooth efficiency of a man who had made similar offers in similar rooms many times. Clive's full cooperation in the federal investigation of Gill-Teague documented testimony, access to records Clive had personally retained in exchange for a mitigation recommendation on the domestic charges. A medical expert would testify to stress-induced behavioral disruption. Sentencing would reflect that context. Fenn acknowledged the offer's federal value. He accepted Clive's cooperation on the Teague matter as a parallel federal track. The charges before Judge Spate's court, he said, stood as filed. Sondheim had expected this answer, but expecting an outcome and receiving it are different weights. He began to respond. Mr. Sondheim, Judge Spate's voice was the same temperature it had been for the entire proceeding, not cold, not warm, precise. The charges as filed will proceed to trial. If your client wishes to cooperate with federal investigators, that arrangement is between him and the prosecution and does not alter what this court addresses. Is there anything further on the preliminary evidentiary record? Sondheim looked at Clive. Clive looked at the table. For the first time that morning, the composure was not a strategy. It was simply a man sitting very still because there was nothing left to perform. Patrice gave her testimony after the recess. She sat in the witness area with the stillness of someone who had not rehearsed the words, but had made a firm decision about what the moment required, and was honoring that decision with everything she had. Fenn led her through the timeline carefully. What she had known and when, the folder in the printer tray, the conversation where Clive had taken it from her hands and smiled, the escalation over subsequent weeks. The night of the injury, from the moment he came home to the moment she found herself at District 4, trying to find the clearest words for what had happened to her face. She did not cry, not because she wasn't feeling it, I know my daughter, but because she had decided what this moment called for, and she was holding to that decision. Sondheim cross-examined with restraint. He had nothing that genuinely threatened her account, and he understood that pressing a visibly injured woman, whose testimony was corroborated by medical records, bank documents, and her husband's own email correspondence, would accomplish nothing in front of this judge except the quiet destruction of whatever credibility the defense still held. He asked 6 questions. She answered all 6. When it was over, she walked back to the seat beside me, without looking at Clive, without looking at Sondheim, without looking anywhere except forward. I put my hand over hers on the table. She turned her palm up and held it. Judge Spate sustained all charges for trial that afternoon. The trial lasted 5 days. Fenn was precise and unhurried in the way that dismantles a defense built on the assumption that composure is the same as innocence. He moved through the evidence in sequence without detours, with the confidence of a man who understood that the structure itself was the argument. Clive took the stand on the 3rd day. I watched what happens when a carefully maintained version of a person meets sustained cross-examination. The version contracts, recedes. The practiced calm that had carried him through 5 years of family dinners and 1 preliminary hearing and the opening of his own trial ran out of the energy required to sustain it. What remained underneath was not defiance. It was the particular exhaustion of someone who has been maintaining a fiction for 2 years and has simply reached the end of what that requires. Fenn asked him near the end of cross-examination. 1 question. Mr. Aldwood, at any point during the 21 months you were planning this, did you consider what would happen if Patrice said no? A pause. She wasn't supposed to say no. Clive said. Fenn let that sit for 4 seconds. Then he moved on. He didn't need to do anything else with it. The jury would do the rest. The verdict came on the 5th afternoon, guilty on all primary counts. Domestic violence with aggravating circumstance, conspiracy to commit financial fraud, aiding in the preparation of fraudulent medical documentation. The Teague cooperation agreement had been finalized as a parallel federal track during the trial, which meant Clive's sentencing carried the weight of that cooperation as a complexity Fenn had used to ensure the domestic charges weren't diminished in the exchange. Not a reduction, a structure that prevented reduction. Judge Spate sentenced Clive Aldwood to 9 years. Before closing the proceeding, she made 1 statement. She said that financial coercion and physical violence are not separate behaviors that happen to coincide within the same relationship. They are the same behavior, expressed in different registers. The law recognizes them as such. Her court would sentence accordingly. The room was quiet for a moment after she finished. Then it wasn't. Sondheim passed our table as he gathered his papers. He slowed, not to speak, just a momentary reduction in pace, the gesture of a professional acknowledging something he would not say out loud. Then he was gone. Nora leaned toward me. Dinner, she said. You, me, and Patrice. Somewhere that doesn't apologize for the prices. I looked at Patrice, who had been listening. She looked at me. Yes, she said simply. We stood, gathered our things, and walked out of the courtroom down the main corridor toward the entrance. The same 14 steps I had climbed that morning. Now descending, the evening air outside was clear and cold. Patrice stopped at the bottom of the steps and looked back up at the building for a moment. The stone columns, the heavy doors, the permanence of a place built to outlast the things that happened inside it. Is it always that slow, she asked? That careful when it's done right? I said she thought about that. It doesn't feel the way I thought it would. No, I agreed. It rarely does. We walked to the car together. 5 months after the verdict, Dr. Alan Pruitt lost his medical license. The state's psychiatric board's findings cited a pattern of professional conduct incompatible with ethical practice. 3 other families came forward after the decision was published, 3 other cases where a convenient psychiatric opinion had been used as an instrument against someone who hadn't known to look for it. I don't know all their stories. I know they were heard because the board's investigation had established a framework that made hearing them possible. 11 months after the verdict, Gil Teague was indicted by the Federal Financial Crimes Unit. Clive's cooperation had provided enough to build a case that didn't entirely depend on it, which, as Roy had always predicted, was how it would go. Teague had been careful for a long time. He had simply at some point miscalculated the situation on the other end of one of his arrangements. Patrice moved into her own apartment in the spring. She had found the neighborhood herself, chosen the building herself, signed the lease herself, and presented it to me one evening over dinner with the quiet self-possession of someone who had learned, at significant cost, that her own decisions belonged to her. It has good light in the kitchen, she said, showing me photographs, and a courtyard. It looks right, I said. On moving day, I helped carry boxes and did not offer opinions about furniture placement unless she asked. She asked twice. Both times I told her what I actually thought, because I had also learned something in the preceding months. A parent's honest opinion, when genuinely requested, is different from one that arrives uninvited. By evening, the main rooms were arranged. We ordered food and sat on the floor because the chairs were still in the bedroom, and we talked for a long time about things that had nothing to do with Clive or courts or evidence. Her work, a trip she was thinking about somewhere with a coast and no particular itinerary. What came next? When I left, she walked me to the door, Dad. She looked at me the way adults look at their parents when they want to say something true and haven't yet found the exact form for it. I should have told you sooner. About all of it. I thought about the honest answer. Not the comfortable one. Yes, I said. You should have. She accepted that. But I understand why you didn't, I continued. And understanding why doesn't mean it was right. It means you're human. And so am I, and we're going to be fine regardless. She held that for a moment. Then she smiled. The full kind, the kind that reached all the way. Okay, she said. Okay, I agreed. I drove home on empty roads. The property was quiet when I got there. I went into the shop out back, turned on the work light, and stood for a while with my tools around me in the particular silence of a space where things get built and fixed. Clive Aldwood had constructed his plan around a retired tradesman with 8.3 acres and no active leverage. He had spent 21 months on the architecture of it. He had retained an attorney, paid a psychiatrist, cultivated a financial intermediary, and prepared documentation in my daughter's name. He had missed one variable. She still had my number, and I still answered. Stories about institutions tend to focus on their failures. What gets less attention is how they function when the right information reaches them through the right channels at the right time, not as a guarantee, but as a possibility that patient methodical work can sometimes make real. The gap between those two outcomes is often narrower than it appears from the outside, and wider than it looks from within.